please be seated. Okay, we're going on the record, case 10-19-2341, State versus Kenneth Jones. Danny Clark for the state, Smith for the defendant on the record. Based upon the charges, the pending charges that have been filed in this matter, as well as the number of victims involved, the community interest in this particular charge in this proceeding, I have opened this up to an in-courtroom session. I've allowed a number of individuals in, including victims, representatives of the victims, as well as law enforcement and the media. I felt like in the public interest that was the correct thing to do. I have in front of me a plea agreement. Mr. Smith, are we going forward with the change of plea?
We are, Your Honor, yes.
You reviewed this agreement with your client where you believe your client is participating freely and voluntarily.
I have, yes.
All right, Mr. Jones, I need to review the new charges with you as well as the plea agreement. I do need your responses under oath, so if you'll please stand or raise your right hand.
Do you solemnly swear the testimony you're about to give in this pending cause shall be the truth, the whole truth, and nothing but the truth, so help you God?
All right, thank you. You may have a seat. First of all, this is a pretty important step, and I want to make sure you're thinking clearly. Are you currently under the influence of any medication, alcohol, or drugs? No, sir. Do you feel like you are thinking clearly? Yes, sir. As you will recall, the original charge in this was murder in the second degree pursuant to a plea agreement. That's going to be amended. Let me just go through that plea agreement with you. Have you had a chance to fully review the plea agreement? Yes, sir. And did you sign the agreement? Yes, sir. All right, under the agreement, count one would then be amended to a charge of voluntary manslaughter. Voluntary manslaughter is a felony. It carries a potential penalty of up to 15 years imprisonment, up to a $15,000 fine, possible $5,000 compensatory fine. If convicted, you could also be subject to restitution, court costs, and victims relief fund. So do you have any questions about that charge or the potential penalty? No, sir. Does that sound like the agreement to you so far? Correct, sir. The agreement goes on that you would also plead guilty to count two. That's the same as the original charge, which is destruction, alteration, or concealment of evidence. Does that sound correct to you? Yes, sir. That particular charge is also a felony. It carries a potential penalty of 5 years imprisonment, up to a $15,000 fine. Do you have any questions about that charge or the potential penalty? No, sir. Count three is a misdemeanor charge, resisting or obstructing an officer, which is a charge that carries a potential penalty of 1 year in jail and a $1,000 fine. Do you have any questions about that charge or potential penalty? No, sir. Under the agreement, you would also plead guilty to count three. Is that your understanding? Yes. I do have a motion to amend the information consistent with the plea agreement. I will grant that motion. With the amended information, then, you do have, as we just talked about, count one, voluntary manslaughter, count two, destruction, alteration, or concealment of evidence, count three, resisting or obstructing an officer. You will have a right to have these charges read to you. Is that something you would be interested in? No, sir. All right. Going back to the plea agreement, then, it indicates that there would be a joint agreement. Both you and your attorney and the state would make a recommendation that on count one, there would be a sentence of 15 years with 9 years fixed, 6 years indeterminate. Does that sound correct to you? Correct. Count two, there would be a joint recommendation for a sentence of 5 years indeterminate. Does that sound correct to you? Yes, sir. And then on count three, a joint recommendation of 1 year, and that would be imposed. Does that sound correct? Yes, sir. And then the agreement goes on that the parties, meaning you and the state, would jointly agree that the sentences on these three charges would run consecutive one to another. You know what it means when we talk about a consecutive sentence? Yes, sir. So in effect, then, with these three charges combined, the sentence would be for a total of 21 years with 10 years being fixed. Does that sound correct to you? Yes, sir. The agreement goes on that the sentence would not be suspended, probation would not be an option, the court further would not retain jurisdiction. Is that your understanding of the plea agreement?
Yes, sir.
And then it also notes that you're currently in custody on a 2011 case, and that continues until November of 2023. And that the parties are free to argue and the court has discretion to make a determination as to whether the sentences in this case would run concurrent or consecutive to that 2011 case. That's how I read this agreement. Is that your understanding as well?
Yes, sir.
The agreement goes on that it would be binding on the court, meaning it would be partially binding on the court, meaning that if I do not follow the sentencing recommendations on these charges, you or the state would have the right to have the plea withdrawn, and we would go back and reset this matter for a jury trial. If I do follow the recommendations of the sentencing recommendations on these charges, then neither you or the state would have a right to withdraw the guilty plea. Is that your understanding?
Yes, sir.
One portion of the sentence that is not binding on the court is whether or not the sentencing in this case and on these charges would run consecutive or concurrent with that 2011 case. Is that your understanding?
Yes, sir.
Does that sound like the agreement to you?
Yes, sir.
That is the essence of the agreement. Do you feel like there's anything else you've agreed to that should be part of the agreement that we haven't talked about?
I think it was well covered.
You feel like you're being pressured or forced into this agreement?
No, sir.
You feel like you are participating in this plea agreement freely and voluntarily?
Yes, sir.
On that 2011 case, you're not on parole or anything like that, are you?
No, sir.
So you're just going to serve your time until November of 2023?
I was up for parole this March, but in lieu of the new charges, I'm sure that's probably all right.
Are you on probation or parole in any other matter?
No, sir.
With the plea of guilty, I order a pre-sentence report. That report will give me information regarding your background, work history, family history, any prior criminal history. Those are all things I look at. They help me become more familiar with you, and they help me with the sentencing. Do you have any questions about that process?
No, sir.
That pre-sentence report will likely contain a sentencing recommendation as well. So again, at the time of sentencing, I will have the recommendations from you and your attorney and recommendations from the state and a recommendation from the pre-sentence investigator. And although the agreement indicates that it's partially binding, in reality, it's not. I can do what I think is appropriate. That can be to follow the recommendations or not follow the recommendations. Again, if I choose not to follow the recommendations, that then opens the door to you and the state to withdraw the guilty plea and go back and go forward with the trial. Do you understand that?
Yes, sir.
Again, if I do follow the recommendation, I have that option. So any questions about the process and preparation of a pre-sentence report?
No, sir.
With a felony conviction, you lose certain civil rights. You lose the right to vote, the right to be on a jury, the right to be in possession of a firearm. So this felony conviction does have an effect on civil rights. Do you have any questions about that?
No, sir.
You do have the right to proceed forward on a jury trial on these charges. At the jury trial, it would be the state that bears the burden of proof, which means the state would need to present evidence to convince the jury of 12 that you're guilty beyond a reasonable doubt. You're not obligated to produce any evidence, but you have the right to do so. You could challenge the state's witnesses. You could call your own witnesses. You could even choose to testify if you wanted to. But nobody could force you to testify. You do retain the right against self-incrimination. So that choice would have to be yours. If you plead guilty, though, you are waiving or giving up your right to a jury trial. Do you understand that?
Yes.
You'd also be waiving or giving up your right to require the state to prove your guilt. Understand that?
Yes, sir.
Do you feel like there's anything else you would like to do or have your attorney do before going forward with this plea?
Not at this time.
All right, so I'm going to go through these charges and just ask you how you plead. Again, this is based on the amended information, which the court has granted the motion to the amended information. Count one then is a charge of voluntary manslaughter. How do you plead?
Guilty.
All right, tell me what you did, which makes you guilty of this charge.
First off, I'd like to say that I know sorry is a very inadequate word to apologize for what happened that day, but I want the victims to know that I am very sorry. Unfortunately, because of an altercation that happened that day and my actions, I pushed her, causing her to fall back and hit her head, and which she never recovered from.
All right, this is alleged to have been about August 20th of 2007. Does that sound right?
Correct.
And this all occurred in Bonneville County.
Yes, sir.
Part of the allegation that this all occurred during a sudden quarrel where you made physical contact with her, causing her to fall and hit her head. Does that sound accurate then?
Yes, sir, that's correct.
Count two is a charge of destruction, alteration, or concealment of evidence. How do you plead to that charge?
Guilty.
All right, tell me what you did, which makes you guilty of this charge.
My great shame, I didn't know what else to do, and I panicked, and I tried to conceal her body in the foothills.
Again, this is alleged to have been about August 20, 2007. Does that sound right?
Yes, sir.
And part of the allegation is that you took the body and hid it in a shallow grave in the Ammon foothills. Does that sound correct?
Yes, sir.
And this all occurred in Bonneville County as well.
Correct.
Count three is the charge of resisting or obstruction of officers. How do you plead to that charge?
Guilty.
And tell me what you did that makes you guilty of this charge.
In lieu of repeated attempts by officers and various detectives, I continually lied to them about events that happened that day.
This is again on or about August 20th, 2007 or thereafter, all occurring in Bonneville County. Does that sound correct?
Correct.
All right. Mr. Clark, you satisfied?
Your Honor, yes, except I think there needs to be an identification of the victim and being a human being. We discussed her, but that's all that's been said.
All right, good enough. All of these charges relate to Stephanie Eldredge. Do you understand that?
Yes, sir.
When we talk about voluntary manslaughter, are we talking about you pushing and causing Stephanie Eldredge to fall and resulting in her death?
That is correct, sir.
And on the destruction, alteration, and concealment of evidence, you're again talking about the body of Stephanie Eldredge being concealed and buried in a shallow grave. Is that correct?
Correct, sir.
And then obstruction of officers is during the investigation of her disappearance. And were you lying about your knowledge of what happened to Stephanie Eldredge?
Correct, sir.
Mr. Clark, does that cover it?
Yes, thank you.
Your Honor, if I might, one other thing that may be beneficial is, as the court's well aware, we had a 2-day mediation that ended late last night. We're here today in front of the court. My client fully intends to write out his statement, and we will do that for purposes of the PSI. We would have done that before now, but in lieu of time getting this set quickly, that didn't happen. So anybody else who might have any trepidation about his allocution today, there will be more of that to come. It just hasn't been able to happen because of the timing of things.
All right, understood. Based upon the statements of defendant, the court finds there's a factual basis for the plea on these amended charges. The court finds that the plea is being entered involuntarily. Therefore, accept that. I will direct the clerk to enter pleas of guilty on these amended charges. We'll order the preparation of a pre-sentence report. We'll set this for sentencing. That will be January 7th at 1:30 p.m. That will be an in-court session as well.
Judge, I'm sorry about that date. I know that I'm in Salmon that day in trial, and I understand it's going unless COVID numbers don't allow it. Is there a possibility for us to set it a week or two after that date?
January 14th.
Let's do it, Judge. If I run into a problem, I'll certainly let you know ahead of time, but I don't think that'll be a problem if that is okay.
Mark?
Your Honor, I don't know if the court wants to entertain these right now versus later, but we've got an issue with the 14th. We would prefer it to be not on that day.
And I'm fine with that, Judge. I know I'm the client and the witness here, so whatever works for Mr. Clark and the victim.
I'll give you more dates and tell me whether they're gonna work. 21st? That'll be 1:30 in the afternoon.
I think that's fine with the state, Your Honor.
Fine with us, Your Honor.
All right, so again, preparation of pre-sentence report with the sentencing on January 21st at 1:30 PM in the courtroom. Go forward from there. Anything else at this time, Mr. Smith?
Judge, the only other thing, and I think fairly standard under the circumstances, but I think the parties talked yesterday about mental health evaluation being ordered as part of the PSI, so.
Well, they do a screening, they do a mental health screening. Right?
That's what we're requesting.
All right, so they'll typically, if the pre-sentence report feels like a more in-depth evaluation is required, then I get word of that, and you can order that if necessary.
Understand.
Anything else, Mr. Clark?
No, Your Honor, thank you.
All right, if there's nothing else, we'll be in recess. Thank you.